whatsoever at the podium, you may use your electronic devices to assist you in the argument. Thank you. Please rise. The justices of the Appellate Division Supreme Court first department. Please hear you or persons that have business with the Appellate Division. Draw near to your attendance and stop the hearing. Please be seated.
Good afternoon. Welcome to the Appellate Division, First Department. Hope all of you are doing well. We have about 6.5 hours of argument that have been requested, so I ask that you please keep that in mind when I call the calendar and ask only for the time that you absolutely need to make the most important points that you wish to convey. Remember that we have your briefs, we have the record, we're fully familiar with the facts of your cases, okay? First case is People versus Sheck Fall.
Good afternoon, Your Honor. Appellant request 5 and 2.
Yes. 5, 2, and 5, thank you. Countrywide versus Dela Cruz. Is the respondent here? You're the only party. Do you wish to submit? Okay. Thank you. We'll take the submission. Submit. Anthony L. versus Bernadette R. Submitted. Let me see. Is everybody hearing me okay? Yes. Stroutmanis versus GMDC 2 Corp. No appellant? Do you wish to submit? Okay, a submission. Thank you. Aquin Loan versus Pacheco. Appellant is not here. Okay. Should we ask him? I guess. Okay, no. Submitted. People versus Jamal McLeod. Submitted. Reyes versus New York City Transit Authority.
For Reyes, we'd like 5 and 2. Robert K. Ryan for transit, 4 minutes, please.
That's it. That's all parties. Yeah. Dyer Crew versus Schindler Elevator. It appears we have no respondent. Okay, I'll take it on submission, thank you. Barham versus Pearson, or Person?
7 minutes, Your Honor, per person.
And you are the respondent?
He's not going to show up.
You represent Person?
Yes.
Okay, you're the appellant.
7 minutes.
So there's no respondent then, you understand? There's no respondent. Do you still wish to argue?
I can submit a written argument if you'd like.
Yes, that would be fine with us. I just want you to know that there's no, we have the briefs on this case. So we want you to understand that the respondent is not appearing. You're the only one who is here. If you wish to submit, we will rely on the record before us right now, the briefs. If you wish to argue, I will give you 2 minutes.
Yeah, I do wish to argue.
Okay, we'll give you the 2 minutes. 2 minutes and a submission. New York Civil Liberties versus the New York City Police Department. 5, 2, and 4, thank you. Gabden versus Williams. Submitted. People versus Paulino Camacho. Submitted. 3650 White Plains Corp. versus Mama G African Kitchen. 5, 2, and 4. Thank you. Winkler versus Hallmark International.
Appellate, Your Honor, 3 and 2.
It appears there's no respondent.
I'll submit it then, Your Honor.
Okay, submission. Sanyang versus Davis is a submission. We're going to call New York Civil Liberties out of order. We're going to call that first. Justice Gesmer is recused, and Justice Manny Mendez will be vouched in. You may begin.
Thank you, Your Honors. Bobby Hodgson for the petitioner, the NYCLU. This FOIL appeal concerns now a handful of city records containing information that is overwhelmingly already public, the release of which presents no plausible possibility of endangering anyone. They've been withheld based on the city's invocation of FOIL's public safety exemption, but the record here and all logic reveal that there is simply no connection between the city's justifications and these particular withholdings.
So, counsel, under the public safety exemptions of FOIL, the city only has to show a possibility that the disclosure of these materials would endanger public safety. So why wasn't that standard met here, where the disclosure of that sensitive public safety information, if it was made public and would be on the internet, et cetera, would be accessible to all kinds of people, terrorists, criminals, whoever with bad intent? Why wouldn't that then be detrimental to the public?
Because the city has not shown a possibility of endangerment regarding these particular records. They have shown a possibility regarding other records that are not at issue on this case. I think it is important to discuss with specificity what's at issue here, because the NYPD is often talking about records that are not at issue. So there are 3 categories of records here. The first of which is records showing the total aggregate number of school safety agents in each borough of the city. Nothing more specific than that, nothing school specific, where the city's own primary affidavit has already revealed the citywide total of 5,000 school safety agents. And where the
So then, but you wanted to be more specific with regard to that.
slightly more specific. These are borough-wide numbers. And the same affidavit has also revealed explicitly that staffing levels vary significantly at each school. And in the same affidavit, I will say in another paragraph that the city describes, quote unquote, an aggregate number as the type of information the city thinks it's safe to release as compared with specific information. The city has conceded.
You want that they have it, it's not in that affidavit then?
Well, that affidavit that the city has conceded does not actually address these issues. That affidavit is only about school-specific school safety agent numbers, and that affidavit is completely silent on this issue of borough-wide. So this is the point I'm trying to make, that their support simply is not connected to these records. The second set of records—
You want to know the amount of the school safety agents, the number of school safety agents in the entire borough.
in the entire borough, where they've already revealed there are 5,000 in the city.
Borough, so that then they would be able to, I mean, I think their fear is, so then they could divide the number roughly and then figure out roughly how many there could be at certain schools and perhaps infiltrate schools based on those numbers.
But that same affidavit confirms explicitly that school-by-school levels vary wildly, and so you would not be able to perform that division. That is an argument their attorney presented in his affirmation as a legal argument, but it is not based in the record here, and it's simply too abstract to support their particularized and specific burden to show a reason. So the second set of records, very quickly, again, show a citywide aggregate list of the types of items confiscated as a result of public school metal detector use, where the city itself has already revealed this exact information for many years.
For the city, though, again, and so that they use the same example, again, of the kinds of weapons that might get past a metal detector.
If I may, Your Honor.
Yes.
Again, the affidavit of Pamela Lightsey, the city concedes, is silent on this issue. That is an attorney's argument trying to retroactively construct a justification for withholding this aggregate citywide list. And we point out in our brief on reply at page 4, notes 4 and 5, I want to say, the city is up to date, up to the minute, revealing both specific and aggregate lists of exactly this information.
For the city, not for the borough, and you want it for the borough.
No. On this, we do not want it for the borough. This is a citywide list of the types of items that are confiscated in metal detectors, which is constantly revealed by the city itself in aggregate numbers just of the type we're asking for. Regarding 2021 and 2020, the number of knives, the number 1,100 knives versus 1,400 knives. This is information that's already public.
But you're asking for the kinds that are, I think, the kinds that get through the metal detectors, the kinds that are like.
No, Your Honor, we're not asking for that at all. Okay. We are simply
They seem to
asking
be
for their list.
concerned. They seem to be concerned that people will be able to figure out the types of weapons that are seized, and thereby figure out the kinds that maybe aren't seized that can get through.
I see my time is up. May I answer?
Yes.
If they were truly concerned about that, they wouldn't themselves reveal much more specific, detailed versions of this exact information, even more recently than the records at issue here. Again, their primary affidavit is completely silent on this, and that concern is not tied to the record. I will reserve the rest of my time. Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the Court. My name is Wamika Jibi, and I'll be hearing on behalf of the NYPD. It is a sad but certain fact that public schools in this country, including schools in this city, face a number of serious public safety threats. The record in this case lays out these threats in detail at 195 to 199, 204, 209, 221, and 263 to 266.
So, counsel, having read Ms. Lightley's affidavit, where she talks about the importance of the tactical principle of uncertainty and the deterrent effect of maintaining these records confidential, what say you with respect to your adversary's argument that all that's wanted is an aggregate numbers per borough?
So, Your Honor, the tactical principle of uncertainty is important. Two reasons for the borough level information. First, not disclosing borough level numbers gives the NYPD, frankly, a lot of bang for their buck. Imagine if the numbers of school safety officers in
Can you
one
slow
borough
down
was
just a little
something as
bit?
small as 3.
Counsel, slow down just a little bit.
Oh, okay.
Thank you.
Imagine for a moment that the number of school safety officers in one borough was just 3. That would
I mean,
give...
but, okay, that's reasonable, I see that, but I doubt it's 3. And if one could argue and one could state in a affidavit that the numbers of a specific borough are so much less than the aggregate that would cause problems, or so much different without saying which borough, if it really is significant. But at this point, there's nothing to identify why all information would be held and not revealed.
So appellant forgets that there's in the record, even before the light say affidavit, that in response to the FOIA request, the NYPD, a record, I believe it's page 99, it explains that borough level information is problematic because it's easy, as Your Honor mentioned before, to average. It's not necessary for the NYPD to go at length about what's obvious. It's a very simple point. Providing more information to a potential shooter allows them to target soft targets, and that's the reason for withholding the specific information. Appellant says that there's a lot of contradiction between the fact that the NYPD has released a lot of information, is withholding these specific documents. The point is that it's necessary for the government, including the NYPD, to be transparent. So the goal is always to provide as much information as possible. But here, in these specific circumstances, they carefully vetted the information to decide what was possible to release and what needed to be maintained for the purposes of the tactical principle of uncertainty.
Counsel, is there any indication at any point that this information will be kept confidential? I didn't see any reference to that in the record.
I'm sorry, I didn't quite catch the entire question.
Is there any indication anywhere that the information that your adversary seeks would be maintained in a confidential manner? I didn't see that anywhere.
No, Your Honor, and it's this court's position that the intent of use for a FOIL request is not important. The court just needs to assume that this information, once it's disclosed, could be disclosed widely, and that's the operational standard the court needs to consider when thinking about releasing this information to this particular appellant. I'll just add that the appellant is trying to craft a narrative that the NYPD is not disclosing any information related to the School Safety Act. And the record actually belies that point. When, in response to the FOIL request, there was a link that provided the information that the NYPD has disclosed publicly under the School Safety Act. And that includes a lot of rich information that would allow any advocacy group, including appellant, to understand some of the challenges facing school safety officers and their interaction with students. There's information about complaints made to the officers, information about how those complaints are addressed, information about students' interventions and the nature of those interventions, the race of the student being intervened against. And the point is that this is not a question of the NYPD attempting to avoid transparency or avoid accountability.
Thank you.
Thank you, Your Honor. Your Honors, two quick points. Your Honor's questions reveal the absolute lack of any specificity in connection between the Lightsey affidavit, which is the record at issue here and their justifications, and these particular records that they are withholding. Counsel has relied again and again on the vaguest articulation of a principle of uncertainty, but that is encouraging this court to completely ignore a record that is absent of any discussion of these particular records, and to allow the city complete discretion to withhold based on any invocation of the public safety exemption. It's asking this court to rule as a matter of law that virtually any conclusory invocation of the public safety exemption can swallow the rest of FOIL, render the presumption of disclosure completely meaningless, with no factual basis that's actually tied to the record here.
Counsel, haven't you requested the number of school safety agents assigned to each school?
No, that is not at appeal. I want to clarify that very clearly. That is not at issue on appeal. We are simply challenging their withholding of these borough-wide aggregate numbers when they are already revealing the citywide aggregate number. There is an additional category of documents we have not discussed. Again, it is metal detectors, where administrators of schools have requested the removal of metal detectors across the city and the location of metal detectors across the city.
So you
Again,
want to
our
know,
record-
in that instance, just to be clear, you want to know which schools removed requested removal of the metal detectors?
So there is a public reporting requirement to the city council that the city explain when administrators themselves are asking for metal detectors to be removed and whether that's granted. That's very important public information, and that's at the heart of the withheld.
It's a simple question.
Sure.
You want to know which schools have requested the removal of the metal detectors.
Yes, Your Honor.
So then wouldn't that expose those schools to safety issues if someone knows that there used to be 5 and now 2 have been removed, or now there are no safety metal detectors at that school? Wouldn't that pose a threat?
It would not, Your Honor, because as is clear in the record, the city already reveals whether there are metal detectors in over 1,000 schools across the city with
Whether there
up-to-date
are
information.
metal detectors, not how many per school or et cetera, or which schools.
No, yes, which schools,
Okay,
exactly
which
which schools in over 1,000 schools across the city. And yet this particular information it's withholding when it has already revealed much more specific information about the location of metal detectors, the type of metal detectors, and tied to specific evidence in schools.
And so now they should indicate whether they remove the metal detectors from those schools.
That's one piece
So
of
wouldn't you
information.
be able to deduct from what they've given you already, which ones from year to year have the information, have the detectors, or don't have the detectors? This is information that they update each year. Is that right?
It's possible we could, but that's not, the burden is, of course, on the
Yes,
defendants
I
to show why
understand
they're
that.
withholding it. And here, again, they
But
haven't.
they have indicated for safety reasons, they've said that's why they're withholding it, so that the school is not vulnerable when the item is
They did
indicated
not, in their
removed.
briefing or in their affirmation, address the specific point Your Honor is making or suggest that knowing which administrators have requested removal is in any way a safety threat. Again, that is absent from the record. They just make a broad statement that in general, knowing where metal detectors might be could be dangerous, but it's belied by their own disclosures.
Thank you.
Thank you, Your Honor.
Thank you both. Thanks, Manny. We're going to go up to the first case on the calendar now, People versus Chick Fall. We'll just wait for Justice Gesma to return. You may begin.
Good afternoon, Your Honors. Matthew Christiana on behalf of Appellant Mr. Fall. I would like to start by addressing the jury charge issue and then briefly touch on my client's sentence. In this case, Mr. Fall was entitled to the expanded instruction on justification. As a preliminary matter, the issue is properly preserved and properly before this court.
That, you're talking about the reputation for violence, right?
Yes,
That
Your
there
Honor.
was an there was a modification to the justification to indicate to include the reputation for violence. But what evidence was there of the reputation for violence of the decedent?
Yes, Your Honor. 2 points in response. First, the charge, either reputation or specific acts evidence would have been appropriate for.
Is there any evidence in the trial with respect to that?
Yes, Your Honor, there's evidence, whether it be characterized as reputation evidence or specific acts. And specifically, in this case, we have evidence that the decedent had always carried a knife that he had.
But that went to specific acts, but there was no, I guess what I'm saying is he asked for reputation in the reputation evidence, but there wasn't any reputation evidence. There was evidence of specific acts, and he gave specific acts to justify the reputation. Isn't that what happened?
Your Honor, to the extent that counsel did refer to the charge as a reputation for evidence charge, but the charge itself encompasses both. So how counsel may have referred to the charge is inconsequential in this case because there was evidence of both, whether it be characterized as reputation or specific acts. And in this case, our position is that there's not such a hard-lined definition of what constitutes reputation evidence to warrant the charge, and that's clear by the citation to People versus Miller, especially in a case like this where specific acts are going to bear more probative on Mr. Fall's subjective belief that imminent or that the decedent's threat was going to be followed through with, especially considering the acts 2 days before that Mr. Fall was assaulted by the decedent, that the decedent had assaulted a security guard in the past, that had been arrested for that the decedent had always carried a box cutter, that the decedent had brandished that box cutter to Mr. Fall's mother. All of these facts are probative on Mr. Fall's subjective belief and are relevant for the requested charge.
Just it was asked already, but was there testimony from the mother? I know there was testimony from the defendant, but was there testimony from the mother about the decedent brandishing this box cutter or whatever at her?
Yes. Yes, Your Honor. Mr. Fall's mother testified that she had seen the knife on one occasion. She had asked him to go home, and there was the decedent had showed her the knife.
But showed her the knife. Are you saying he menaced her with the knife, threatened her with the knife? He just had the knife? What was the testimony?
The testimony was that he showed her that he had a knife on him.
Which is not exactly testimony of...
But it goes to whether or not the decedent always carried this knife, which was Mr. Fall's concern when the decedent threatened him, saying that he was going to kill him.
Isn't that undercut by the incident between the two of them the previous week when they got into an altercation and the victim then ran away? That's not what somebody with a reputation for violence you would think would do, right?
Well, Your Honor, if anything, I believe that goes more towards the possibility that the decedent was going to follow through with his threat on the occasion inside the store, because on that separate occasion, the decedent attacked Mr. Fall, and there was a lot of people there, and then he ran away after the fact. So that goes to show that the decedent was willing to assault Mr. Fall, and in the store, when it was just the two of them, he could have, or as far as Mr. Fall believed, was going to follow through with the threat that he was going to kill him. And just briefly, Your Honors, the error in this case was not harmless. This was a very close case. The jury struggled to reach their verdict. They sent 24 notes. Among those 24 notes were definitions of first-degree manslaughter, reasonable doubt, justification, initial aggressor, what a reasonable person would do, and whether a verbal threat could make somebody an initial aggressor. The jury also necessitated 2 Allen charges and deliberated for multiple days before they ultimately acquitted Mr. Fall of the premeditated count. So this error was not harmless. And if briefly I may touch on my client's sentence, again, Your Honors, this was not a premeditated or intentional incident. This was an incident that happened in the heat of the moment in 10 seconds, and Mr. Fall has exhibited remorse ever since at every stage, from trial through sentencing.
I looked at the video. Where was the heat of the moment, counsel?
Mr. Fall had asked the decedent to enter the store because he wanted to settle their issues. They were once close friends, and Mr. Fall wanted to put this past him. When they entered into the store, that's when the decedent threatened Mr. Fall that he was going to kill him. In that moment, Mr. Fall reasonably believed that his life was in imminent danger, and he just reacted. And the jury's verdict, we believe, also proves as much because they acquitted him of the intentional count in this case. Thank you, Your Honors.
Thank you.
Good afternoon, Your Honors. Jared Walkowitz for the People. I first want to start by talking about People v. Miller, because reputation for violence in the community is a specific piece of evidence. You have to ask a witness, did the victim have a reputation for violence in the community? And the purpose of Miller, the case itself, was to say, could we have another branch of evidence, which are specific acts of violence? And Miller said, yes, in addition. So these are not the same thing as my adversary tries to point out. These are 2 separate, distinct bodies of law. And the evidence, the charge, the application, I think in his reply brief he calls it a colloquialism, It's an application. It's not a colloquialism. He asked for reputation for violence in the community, and he said it was, and I quote, heard. It was not heard. He then said that the charge should be modified accordingly. He did, as counsel pointed out, submit a standard charge where there was both angles to it, the reputation for violence and the specific violence. But that's not how he framed it to the court. And in the very first paragraph of that charge, Your Honors, he says reputation for violence, that the jury heard reputation for violence and specific acts of violence. The jury never heard reputation for violence. So the court, just given the instruction that they provided, was not an appropriate instruction. And the court's not there to make applications, it's there to decide disputes. I would also add, with respect to the charge, that in terms of the specific acts of violence that he talks about, it was negligible for some of the reasons as the court was pointing out. In Miller, it says the defendant has to know about these things and has to be reasonably related. One, like the fight that Your Honor was discussing, Justice Gessmer was discussing, the defendant marched up to him. There seems to be some sort of pushing. The victim falls to, I'm sorry, the victim punches the defendant falls to the ground, the victim runs away. He doesn't press his advantage. He doesn't take out that box cutter. How would that, if they made an application based upon that, the court may very well have said that was not a specific act, that evidence was simply omitted to show the background of what was going on here for this attack later on. The box cutter is not illegal. The victim had had odd jobs. It certainly wasn't out of the norm for someone who has odd jobs to carry a box cutter.
I'm confused, counsel. Was there a box cutter found at the scene?
No. But that's what they claim, so I'm just going to give it in their life and just saying whether they would have had a charge or not. So, yes, as Your Honors were alluding to, none of this evidence that defendant talks about as specific acts of violence necessarily would have supported a charge. They would have had to make that application how each one of them, that the defendant knew about it and are reasonably related to the charge itself. That was not made. And he was not entitled to that charge for the reasons we discussed in the brief. In addition, I just want to say another thing. The jury, in any event, was plainly instructed on what the defendant knew at that time, because the charge states the defendant, in the defendant's position, knowing what the
Thank you, counsel.
Thank you.
Just 2 points briefly, Your Honor. With respect to whether or not there was a box cutter found, there was no box cutter found, but the surveillance video in this case shows that Mr. Fall and another gentleman by the name of Rome were bending over, picking up items where the altercation took place. So it is our position that as Mr. Fall testified, that there was a box cutter, but that somebody had picked it up and it was never recovered. With respect to the charge itself.
Counsel,
But that's pure speculation, isn't it?
Yeah.
I'm sorry.
Isn't that pure speculation?
Yes, Your Honor, but our position is simply that the evidence did not refute Mr. Fall's claim that the decedent had a box cutter, and Mr. Fall also had an injury on his left hand.
I saw the knife in the defendant's hand. I mean, that was clearly displayed on the video. But as far as a box cutter being on the floor, that was not apparent.
No, Your Honor, it was not, but the evidence did not refute that the decedent did have or potentially had a box cutter.
I don't understand that. Is there any evidence in the record that the decedent had a box cutter?
Our position is that there is I believe it was slide 711. There's a portion of the video where it seems to suggest that the decedent is holding something, and he makes contact with Mr. Fall's left hand. Mr. Fall's left hand, 48 hours later, has a cut about an inch wide in the form of a semicircle in the same spot that where the decedent made contact with Mr. Fall. So our position is
48 hours later has a cut?
48, when he was arrested, I believe 48 hours later, they took pictures of his injuries, and there was a cut to that same hand. So simply because the box cutter was never found does not negate Mr. Fall's position that
What
the
page
decedent-
in the record, please, is that photograph?
I'm sorry?
The record page with a photograph of the cut?
I believe it's of Mr. Fall's injuries.
Yes.
I believe it was exhibit.
I saw a description of the cut at two minor cuts, very something small. Now you're talking about a semicircle and so on and so forth.
Yes, Your Honor. I have.
I'm surprised.
The citation. I apologize. The detective did testify that there was a minor cut, but
Right,
in our
I
brief.
saw that part.
Right. In our brief, we cited the relevant exhibit. I believe it was on, yes, it was on page, I apologize, Your Honor, I don't have the citation in front of me, but it was in, we did cite to it in our brief. It was an exhibit.
Thank you.
Thank you, Your Honors.
Thank you, and thank you both. Reyes versus New York City Transit Authority.
Ready? Yes?
No,
No.
just a moment.
Sorry.
Okay, thanks.
Good afternoon, Your Honors. Good to be back in court live again, and special good afternoon to Judge Gesmer. My name is Arthur Schwartz. I am counsel for the Appellate.
See the rest of us?
Excuse me?
You're not happy to see the rest of us?
I said all the rest of you, but we were neighbors for a long time.
Okay.
Arthur Schwartz for the Appellate Transport Workers Union and Mr. Reyes. This is an appeal of an arbitration award or an action to vacate an arbitration award. It is not a case where we are challenging factual findings. Not at all. We are saying that the factual findings are inconsistent with the remedy that was.
You're saying it's irrational? Aren't you saying it's irrational?
It was either irrational in that the determination didn't flow from the facts found by the arbitrator, or that it didn't resolve the entire dispute between the parties, which are two.
But it did resolve the dispute because the arbitrator found that Mr. Reyes was entitled to money and said that the transit authority shouldn't do what it did.
Well,
I mean, what is left to be decided?
The
It seems
arbitrator.
like Mr. Reyes is not satisfied with the amount of money.
Well, the arbitrator made findings. He found there was a discriminatory assignment of overtime. He found that the difference over a 2-year period was $65,000. He then said he was awarding 40 hours of pay for the period before the grievance got filed, which was, he says in the.
And I think your client was retiring or retired, so there was no way to, that's why that was done.
No, Mike, the evidence, he worked the entire year of 2018. So he said he was granting 40 hours of pay. He would only go back 30 days because of limitations in the contract. It was a continuing violation, but he could only go back 30 days. He gave him 40 hours for the 30 days before he filed the grievance, and then didn't discuss the $50,000 difference that he found had existed in 2018. Not at all, didn't remedy it at all.
So you're saying that maybe he made an error in calculation, which of course wouldn't be appealable?
No, I didn't say he made an error in
Okay,
calculation.
so I'm trying to figure out exactly what it is you're saying about the difference in money, that he granted only part of what your client wanted. what your client had requested for that period of time.
He didn't say, for the entire period of time, I'm awarding 40 hours. Then we would have no case. He said, I am granting I can only go back 30 days from the date the grievance was filed, which was January something 2018. So I'm going to give him 40 hours for the period prior to January 2018. But he had made findings that the discrimination continued throughout 2018.
I understand what you're saying. But as you know, an arbitrator is not bound by substantive law necessarily or procedural law, and an error of law or fact. I know you said you didn't have, I think you started by saying you really didn't have any issue with his factual determination.
Right.
But you really are saying that you do, because although he found that period, he found a different amount for what he was going to credit with the monetary award. But an arbitrator is not, an error of law or fact is not reviewable.
Well,
So I'm not really sure what aspect it is.
it's not law. We're not talking about law. There was a case.
You're talking about an error of some sort. You're talking about a factual error or some other error or his determination. Either way, that's not reviewable.
Well, Your Honor, if I was in front of this court 4 years ago in the New York City Transit Authority versus Phillips case. In fact, Judge Gesmer was on the panel. And the panel found that the conclusion drawn by the arbitrator was inconsistent with his factual findings. In that particular case, he found that someone had engaged in sexual harassment. He detailed the incidents, and then he said, but he's not guilty of sexual harassment. He's guilty of inappropriate conduct towards another employee. I'm going to give him a 10-day suspension.
It's a very different factual case, but that's aside.
This court reversed the arbitrator in that case on the same grounds that we're talking about here. There were findings made. In fact, I just argued. I was here last week. Nobody here was on the panel.
I was.
In a case where Judge Nervo had reversed an arbitrator's award because he made certain factual findings and then made an ultimate determination that was totally inconsistent with those findings, the Rivera case.
And we have as many cases that go the other way, I imagine. But in any case, you can respond to that on rebuttal. Okay?
I didn't hear what you just said. I'm sorry.
I beg your pardon? You didn't hear what I said?
I couldn't.
Oh, I'm sorry. I said, and I believe we probably have as many or some cases that go the other way as well. But you can respond to that on rebuttal. That's what I said.
Oh,
okay.
Red light.
You may begin.
Thank you. Good afternoon, and may it please...
counsel, you heard, I'm sorry, did you, I cut you off before you got to...
Robert K. Dryan, here I am. Yes,
Go ahead. Give your notice of appearance, please.
Thank you. I'm ready.
Your appearance.
Did you finish your notice of appearance?
Yes, may it please the court, my name is Robert K. Dryan, and I appear for the Transit Authority, the respondent on this appeal.
Great, thank you. I'd like you to pick up where your opposing counsel left off, in that the judge was inconsistent, as he put it, because he found that he was off there was a certain period during which he was not given the priority of overtime, but only found the 40-hour period of monetary compensation, and that is inconsistent. What is that a basis for reversal on these facts?
It is not, Judge. You can nitpick through arbitration awards and find problems with the language and inconsistencies, and it's not really enough. It puts this court in the position of saying, well, 40 hours doesn't seem like enough. Maybe 80 would be better, or 100. And it's all subjective. It's all relative. It's the whole problem with reviewing findings of fact and the award of either discipline or penalties.
So, counsel, let me be more specific, if I may. So the difference between the hours in 2017 were 1,042 hours of overtime for Ms. Roderick versus 530.3 hours for the plaintiff. And in 2018, effective as of the timing of the filing of the grievance, the difference was between 1,170 hours and 516 hours. So more or less, it's 2 to 1, right?
Yep.
50%.
Yeah.
But what you have is an award of 40 hours. And the differential is for 2000, from what I saw from my calculations, were like 654 hours. So how is that not arbitrary or irrational, please?
Well, I looked at those numbers too, Judge. Obviously, they're pretty startling. When you think of the context here and the fact that no other person was picked out other than this lady, and we don't know if they were on the same tour or shift. And the arbitrator's frustration, as I understood it, was that he waited a whole year to file a grievance. And as the arbitrator said, if he'd made this grievance earlier in the year before, they could have awarded him more overtime, but he didn't do that. He waited more than 12 months to complain about the year before. So it puts the arbitrator in a position where he's missing a lot of data that might have helped him decide what the real context is and what the real loss was and what the real award should be. But this is what he decided. So I'm not sure I agree or don't agree, but that's what the arbitrator thought, and I think I wasn't there, so we have to honor that.
What, is there a 40-hour rule? Sorry, not a 40-hour rule. Is the 30 days rule?
I think the contract has some limitations in terms of when.
said that?
I believe that's the case. I think Mr. Schwartz probably would know for sure, but I believe that they're supposed to file it timely within some time period and not wait forever to do that. And even if there weren't a time period, the arbitrator could still note that he knew it 6 months before, he knew it 10 months before. Why didn't he say something? Why didn't they bring it to arbitration? But this is,
Well,
these are.
why don't you, when you negotiate the contract, put in a specific time limit then?
I'm sorry, I didn't hear you.
You negotiate the provision, the time period is in the collective bargaining agreement, right?
I believe so, yes.
So when you negotiate the agreement, you, the transit authority, negotiate that agreement, why don't you put in a specific time period that you believe is appropriate?
Well, that's a good question. I'm not sure I have the answer right now, Judge. But I think timeframes are important. I think that the collective bargaining agreement, which is massive, contains such things. And even if it didn't, the arbitration award here, the arbitrator assessed the facts, assessed all the variables that he had, and made this decision. And I know my time is up, and so I'm going to wander.
Well, let me just see if there are any other questions first. Did you have a
I
question?
have a question. You said something about that it would have been difficult for the arbitrator to assess because he didn't know what shifts they both worked on. How are the shifts relevant to overtime?
Well, if their RDOs, regular days off, so they may not be working on the same days when overtime was available. If there was overtime, he might not have been available, and she was. There are just a lot of factors. He might have been out sick on certain days. She might have been on vacation certain days. So without any kind of closer examination, it would be really difficult to make a more accurate assessment as to what he would really be entitled to.
And this assessment wasn't possible because he was going to be retiring?
Well, I think that was that's what my interpretation is, that was the arbitrator's frustration, that the man waited so long to bring this when the arbitrator could have awarded him to order transit to give him more overtime, X amount of hours or whatever that might be in an award, but that was not possible by the time the arbitration was held and the award was issued. That's my understanding.
Thank you.
Okay, I have comments about Phillips. It's not relevant, but I'm going to thank you very much for your time.
As if it's not relevant, then you answered your own question. Okay.
Your Honors, I wanted to answer two questions. First of all, two statements made by counsel. First of all, the arbitrator stated, and this is on page A43, grievance testimony that he was improperly bypassed for overtime between the two in favor of Roderick was credible. So he didn't say, I don't know whether it was proper or not. He said his testimony that it was improperly passed over is credible. because the two
But
work
he
this.
also said on the next page that the union could not provide detailed information as to what extent Reyes was bypassed in favor of Roderick, which
Well,
I
I'm
suspect,
not-
I mean, excuse me, which I suspect from context and from the Transit Authority brief and sort of logically probably depends on whether or not he was available when overtime was offered to her, whether he was already working during the time she was offered overtime. If we don't know that, we can't really assess the meaningfulness of the differential in their salary, can we?
But he didn't say that, and in fact,
Well, he did say the union could not provide detailed information as to what extent Reyes was bypassed in favor of Roderick.
and
Isn't
what,
that I mean, I read that as there was a failure of proof that made it difficult for him to assess how much more overtime your client should have received,
but
or could have received.
what Judge Renwick cited was exactly the evidence that he had before him. And in fact, it wasn't 1,170, it was 1,770.
You're going to have to remind me at least what it is you are referring to that you say I cited?
It was actually Judge.
On page A53.
Oh, I think you're talking about Justice Gonzalez on the end. I think maybe
No,
she referred to something.
somebody cited exact numbers and did math.
It was Justice
I'm just saying that the court said 1,170, but the exhibit says 1,770. And that was, so the exhibits that one for 2017 starts at A53, and 2018 starts at A67, which goes through every single day and is a running chart that we made, or we submitted, the arbitrator had in front of him. So I don't know what he talked about not knowing the extent. But the issue here is he gave nothing for the time after the grievance was filed. There was a penalty for before the grievance was filed, and that's he could only go back 30 days. So he blew it, right? He waited until January 2018. He blew all that time. He could have complained about it before. That was his penalty for that. We wouldn't contest that. That's the rule. 30 days. That's what the contract says. You can go back 30 days for money.
Counsel, your
Then he
time is
filed
up, so
it
I'm going
and
to ask that you get to make the point.
I made my point.
You sure?
My point is that
if you want to finish your sentence, I guess I should say, finish your thought.
Right, so the arbitrator only went, there was some discussion of contractual language that limits remedies, and that was the language that limited the penalty. He could only go back 30 days. But it didn't say you couldn't go forward through the next year and award zero, when he knew, and he made a finding that in that year, the difference was $50,000.
Thank you.
Or 1,200 hours.
Thank you.
Thank you.
Thank you both. Barham versus Person?
Your Honors, my name is Carl Pearson. I'm the defendant in this case. I have two corrections to the brief in the table of contents. If you're interested, I think it might save you a little time. The first is Derby, the case citation. There were 7 cites, and I missed that. The correct citation is 89, 83rd, 891. And the second correction is that only one of the 2 CPLRs is correct, and that is CPLR 3212A. The other one should have been called that.
Okay, thank you very much.
Okay. I was going to read my statement, but I think that you're a hot court, so to speak. this case is very complex. I am not a real estate lawyer. I don't do transactions, and therefore I had to spend hundreds of hours learning about a law that I'm not in. I'm not into that, but I learned a lot. And the result is that I see that there is no case at all of malpractice against the original law firm. Now, I made a motion for summary judgment that was 13 days late. 60 days was set forth. Believe me, in a case like this, it should be a lot longer. But I wasn't thinking of 60 days. I was trying to do a motion. The motion took, like, paragraph 19 took more than 100 hours of time to do. The rest of it took a lot of time. I started several days before the note of issue was even filed. And I wasn't thinking of time, I was thinking of getting the thing done. And I did it, and it was 13 days late. There was an argument originally, and then it was adjourned to another date. And at that date, the judge gave my opponent a chance to argue, if he could, that a lawyer could not change from believing originally that there was a case and then coming around to a conclusion that there is no case. The judge gave that chance to file opposition or anything else he wanted. They never did that. We had an adjournment coming up, a continuation, a second continuation, and I never got a chance to tell the judge, and nobody ever raised the issue about belatedness. We went for a year, and
We did read your brief, and these are the arguments that you made in the brief. And
I have
we're
my
aware
written
of all of
argument
it.
if you want to read it.
I don't think we need it, because you gave us the corrections to the brief, and it was pretty thorough. I mean, we understand you're saying there was no but for in the first action, therefore there's no but for in this action, and we have to make the assessment of what happened. And of course, then the judge made a determination that the motion was late, so we will review that in the first instance. Okay?
Is that?
Thank you.
Am I done now, Your Honor?
Well, the red light has been on for a little bit.
Okay, I'm sorry. Thank you.
It's okay, but I just wanted to, you just were repeating what we already have in your brief.
Thank you, Your Honor.
Thank you. $36.50 White Plains Corp. versus Mama G African Kitchen.
Good afternoon, Your Honors. May it please the Court, Joanne Engeldrum from Rivkin Radler on behalf of Appellants 3650 White Plains Corp. And Seneca Insurance Company. The Supreme Court erred in denying Appellant's motion and should have found that Utica First had a duty to defend 3650 in the underlying action. It's settled under New York law that the duty to defend is exceedingly broad and arises whenever the allegations of the underlying complaint suggest the reasonable possibility of coverage.
So just there didn't seem to be any responsibility in either the lease or any other document for structural defect on the part of the tenant, for the tenant to have to be responsible for any structural defect of the sidewalk. It didn't say specifically sidewalk, but everywhere it said tenant is not responsible for any structural defect. And the kinds of things that they were responsible for the sidewalk was keeping it clean, keeping it free of snow. This was a crack, broken sidewalk that a child tripped over. So why is should there be liability? Why should there be coverage here?
Because, Your Honor, In the underlying action, Ms. Castillo, who brought the action on behalf of her infant child, alleges that not only was there the failure to repair the broken sidewalk, which she alleges is structural, but also that Mama G African Kitchen, Utica First named insured, created the defect and also failed to provide barricades, warning signs, lighting. The sole issue is not structural defect in the
The
sidewalk.
plaintiff might think that the tenant didn't repair it, but the lease determines who was responsible for that repair. And it says structural defects are to be repaired by the landlord. So it would have been the landlord's responsibility to repair the structural defect on the sidewalk, wouldn't it?
Assuming that's accurate and that's an issue in the underlying action, but assuming that that is in fact correct, those are not the only allegations as to what caused the accident
So,
in the
counsel, I'm
underlying
looking
action.
at paragraph 38 of the complaint, which says plaintiff fell as a result of dangerous, hazardous, defective condition existing on or about a sidewalk, pathway, or other defective condition at or about the premises. How does responsibility for the cure, if any, of such a condition inure to the tenant? I'm echoing what my colleague is saying. The lease is very clear at paragraph 13. Landlord shall be responsible for any structural repairs and roof repairs that are not caused by the tenant.
Yes, Your Honor, but also in the bill of particulars, well, first, to your point, the complaint also alleges other defective conditions, and then the bill of
Particulars said permitting and allowing the sidewalk on said premises to become and remain in a dangerous, unsafe, and hazardous condition.
and failing to provide barricades, warning signs, and also creating that
Well,
condition.
what evidence is there anywhere that the tenant created it?
There's an allegation that the tenant created it.
By whom, and what does it say?
It says that the tenant was negligent in causing.
Who says this?
I'm sorry, the plaintiff in the underlying
me,
action.
Here.
I'm sorry,
So the plaintiff is the person who was walking one day and tripped. How does the plaintiff, other than a mere allegation, determine who caused a structural defect?
It's alleged, and that's to be determined in the underlying action, and a duty to defend is determined by the allegations, not ultimate liability, and it gives rise to if there's a possibility of coverage. And Utica First additional insured endorsement provides additional insured coverage for $36.50 for liability for bodily injury caused in whole or in part by the acts or omissions of.
It's a structural defect. There's no responsibility for the structural defect.
But
The plaintiff, the tenant, had no responsibility for a structural defect.
But the tenant may have been a proximate cause, not the proximate cause, but a proximate cause by failing to provide
Something there was responsibility for in some way.
There's an allegation that the tenant created the defect, which is being determined in the underlying action. It has not yet been determined. That is at issue, whether or not the tenant created the defect. And also at issue is whether or not the failure to provide proper lighting by the tenant caused the accident, or a barricade when they were aware of the defect, or some sort of warning when they were aware of the defect, and whether or not that was simply a proximate cause. There just has to be an allegation of liability and negligence for there to be a duty to defend.
Thank you.
Thank you.
Good afternoon, Your Honors. Joseph Poe on behalf of Respondent Utica First Insurance Company. I'd like to pick up where the court left off with the appellants. The additional insured endorsement only provides coverage for the proposed additional insured for vicarious liability. And as the court has pointed out, in this instance, the underlying plaintiff specified the cause of her accident as a structural defect. Any other allegations regarding...
How do you address it? But counsel raised the issue of whether the tenant had in some way created that structural defect. How would that affect the allocation of insurance?
Well, Your Honor,
The allegation regarding the creation of the defect was stated in the bill of particulars. That also is where the plaintiff, underlying plaintiff, specified what the defect was that she tripped over, or the child tripped over. Those other allegations must be read in the context of the specific cause of the injury. So from our perspective, the structural defect still is allocated to 3650 White Plains, the owner of the property. Along those lines, the Supreme Court properly considered the lease, which allocated that non-delegable duty to maintain the sidewalk in a reasonably safe condition to the landlord. That's a non-delegable duty under the administrative code that the lease did not specifically shift responsibility for to the tenant, Mama G African Kitchen, which is Utica First's named insured. As a result, there can be no duty to defend for this particular lawsuit.
Thank you.
Thank you.
Your Honors, I just wanted to point out that this additional insured endorsement does not provide coverage for vicarious liability, as counsel stated, but rather for if the named insured was a proximate cause. And that language has been interpreted by the Court of Appeals in the Burlington against New York City Transit Authority matter. And if it was so obvious that the tenant was not liable based upon the allegations and the lease, then candidly, tenant would have moved to be dismissed based upon documentary evidence in the underlying action.
Well, I don't, you know, people make mistakes all the time, so we could tell you 100 cases where we thought it should happen. This could be one of them, but it's not done, so we can't address it.
And the other issue is, I understand that, but the other issue is who caused the accident, what caused the accident, and liability for the accident is all at issue in the underlying action and not for the DJ
So you're
court to
agreeing that
decide.
there's issues of fact? You're agreeing with the decision below?
Well, that's the thing is that, yes, because, but the very existence.
So why is the denial of your motion for partial summary judgment before us on appeal, counsel?
Because the very existence of an issue of fact as to whether, which is what the lower court found, as to whether or not Mama G African Kitchen's acts or omissions were a cause of the accident, which is what the court found there was an issue of fact on, creates a duty to defend. Because where there's the possibility of coverage, regardless of whether there's ultimate liability, the Court of Appeals has held this, and all of the cases are cited in our brief repeatedly, that it's the allegations of potential coverage, i.e. that Mama G African Kitchen was negligent and a proximate cause of the accident is enough to create a duty to defend.
Thank you. Thank you both.
It's been a while.
Lobby, be advised, court is over. You have two coming out.
Last month. And we'll get a decision quickly as well. The second department.